Judge Napolitano, the host of the Judging Freedom Podcast. Good morning, Judge. How are you, sir?
Good morning, Austin. Pleasure to be with you, no matter what we're talking about.
I think we'll skip the discussion about the Spanish Armada this morning, if you don't mind, Judge.
I agree.
Missouri had a bill that took quite a number of years to pass. It was called the Second Amendment Preservation Act. And very briefly, what it does, for those who might not know, is that it prevented Missouri police officers from enforcing federal laws and put a $50,000 fine on their department if they cooperated with the feds in enforcing laws that weren't illegal in Missouri. They could cooperate with the feds if it was against Missouri law, but the feds had to enforce their own federal laws here in Missouri. A federal judge overturned that yesterday. I'd love to hear your thoughts on it.
Well, this is really one of the worst judicial opinions that I've reviewed in the modern era. If this judge were a student of mine at one of the three law schools on whose faculties I was privileged to sit and submitted this, he would have flunked because he missed the most important case, which is a Justice Scalia opinion called Prinz versus the United States, in which the federal government tried to get sheriffs to enforce federal gun law. And the sheriff of Phoenix, Arizona, last name Prinz at the time, challenged that statute, and the Supreme Court said, you can't do it. The feds can't commandeer, Justice Scalia's phrase, local and state law enforcement to enforce federal law. The feds want to enact a federal law and they want it enforced. Let them go ahead and enforce it. There's absolutely no authority under the Constitution whatsoever for the feds to commandeer locals. So this judge missed the case. Now, the most important case. Now, I didn't read the briefs, and I'm sure that the briefs submitted by the Attorney General of Missouri cited that case. How he could miss it, how he can get around it, I really don't know. The statute itself is one of the finest demonstrations of federalism since Thomas Jefferson and James Madison dissented from the Alien and Sedition Acts in 1798 by writing the Virginia and Kentucky resolutions, which supported the concept of nullification. If a federal statute purports to violate a fundamental liberty expressly guaranteed by the Constitution, and we know that's the case from Justice Scalia's opinion in Heller and Justice Thomas's opinion in Bruin, then the states can nullify that federal statute within their states. So this federal judge has totally missed the boat. As for where this goes, I think the statute will eventually be upheld. Whoever crafted this in the Missouri legislature has a superb understanding of federalism and superb timing, knowing that with this present Supreme Court itching to enhance the concept of federalism, to leave the states to protect civil liberties in areas where the feds failed to do so. Here, the civil liberty to defend yourself. I think the court will profoundly alter this ruling that came down yesterday.